Hello, how are you today? Today I like to talk about dismissal after signing employment contract, but he didn't start to work. So whether it can be the justifiable the dismissal or not, I think this is the question. So this is the actual story I have helped for the corporate client. So this case happened that when the one applicant who was supposed to be a Korean branch manager had an interview with the HR managers in the USA. So he passed that interview and he and company signed the employment contract. So she was supposed to join the Korean branch office after 3 weeks. So then he was waiting, and then the company informed the Korean branch Korean branch office they are going to have a new Korean branch manager. So then some of the employees working in Korean branch complained they would resign if he joined this Korean branch office because his character is very too strict. Also, he is very selfish. So in previous company, they could not work along with him. So that's why they quit their job and joined this company. So if he joined this company, they would leave this company. So company was shocked to know that, so they considered how they could handle this case. So they decided to terminate this new Korean branch manager just before he joined this company. So then the Korean branch manager sent an email to the company. They have to compensate some for the illegal termination. So if the company do not compensate, he would take some legal action. Then in this moment, the company asked me to give my legal opinion. So I explained to them this is like after signing the employment contract, company canceled the contract. So it is a violation of Korean labor law, even though there are some articles justifying that the termination in early stage, but Korean labor law explained that there should be justifiable cause for the termination. So I explained also, I explained some similar court cases. So like there are two similar cases. One is during the IMF crisis, one company had some job interview with some applicant, and some selected people will pass that exam and they are supposed to join the company after 2 months. Then because of IMF the situation, company could not hire them, so they delayed. Company delayed to hiring them for coming the 6 months. So then finally, company terminated. Announced that they could not. They canceled this employment contract. Then those new employees applied for remedy application to the court. Then court ruled during the termination period, the company must compensate all wage they could earn for the past 6 months. That was one case. The other case is company had a job interview and passed some selective workers. So then those workers who passed the entrance exam, then company asked them to wait until company informed them to join. Then because of IMF crisis in Korea, company could not hire them, but those who passed that exam had to wait for 1 year period. So then finally company informed them the cancellation of their employment. So those the new workers applied for remedy claim to the court. So court ruled they company have to compensate half year's salary. Also they asked the full 1 year salary, but court accepted only 6 months because there are no exact date for joining. Also employee could get a new job, but they waited. So it is there are 50% some fault belong to the new employees. Also another 50% for companies. So 6 months compensation was accepted. So now I think this the basic question, like this new branch manager, he took legal action to the court for this case, but still in the process of now in the dealing in the court, there are no decision. So workers claim is he want to get the full salary compensation during the dismissed period, and he want reinstatement. But company claimed that he was the Korean branch manager. He is in the position of employer, not the employee. So he is not entitled to asking some workers' rights, something. Or secondary, even though he was employed, there are probationary period, so he could not pass the probationary period. So now court may make a decision for the case. So like company could pay to 1 month salary, but he expect to 1 year salary. So I think a judge may decide about some like something intermediate. I mean some acceptable settlement. It can be a 3 months additional compensation for. I think that can be a very acceptable to both sides. So now, when I deal with such like a cancellation of the new employee who just signed the contract, so this is something HR manager should be careful before they signing the contract of employment. Okay, this is all for today's speech. Thank you for watching. Okay, bye bye.